Greetings everyone, I'm Anushka. Welcome to episode 4 of Inside the Courts by Rahul. This platform brings to you important Supreme Court observations and key legal developments presented in a clear and exam-oriented manner. Let's begin with important judicial observations. In a seminal case of Sabarimala Nair and others versus State of Kerala and another, the Apex Court has quashed proceedings under Section 498A and 494 of the IPC against the husband's relatives, including his parents and sister. The court observed that the complainant's allegation that they were aware of the second marriage is not sufficient to implicate them in the offence of bigamy. The court observed that while it has been alleged that the accused appellants were aware of the second marriage, mere knowledge that an act is being or has been committed by another person does not by itself establish the requisite common intention. Even proceeding on the basis that the accused appellants were aware of the second marriage, there is no allegation, let alone any material, to suggest that they actively participated in, facilitated, or encouraged the solemnization of that marriage. In another important judgment of Nikhat Parveen @Khushbu Khatun versus Rafiq Shilu, the Honorable Supreme Court dismissed an appeal filed by a mother challenging the denial of maintenance to her daughter, affirming the Delhi High Court's decision in the concerned matter and held that when a DNA test conclusively establishes that a man is not the biological father of a child, he cannot be directed to pay maintenance, even though the child was born during the subsistence of marriage. It is important to note that while deciding an application of DNA test, the courts undertake an exercise to balance the interests of the parties and decide whether there is an eminent need for the DNA test. In another significant order, in the case of A, mother of X versus State of Maharashtra and others, the Apex Court allowed termination of a 30-week pregnancy of a woman who had conceived as a minor. Setting aside the Bombay High Court's refusal based on fetal viability and possibility of adoption, the court held that a woman's reproductive autonomy and bodily integrity prevail over considerations relating to the fetus, and that decisional autonomy is a fundamental facet of her rights. It further observed that forcing continuation of an unwanted pregnancy may result in grave physical and psychological harm. It clarified that fetal viability and the option of adoption cannot override the informed choice of the pregnant woman, and that her attaining majority during proceedings is irrelevant where conception occurred while she was a minor. In this case, a contempt petition was filed against the center and aims by the mother of the minor, alleging non-compliance with the court's earlier directions, which was dropped on being informed that the directions have been complied with. The next segment is regarding the roundup of the Sabarimala hearing. On days 6 to 9, the petitioners defended denominational autonomy, arguing that courts should not second-guess religious beliefs through the essential religious practices test. They said Articles 25 and 26 protect a community's right to manage its own affairs and warned that allowing constitutional scrutiny could let courts reshape religion itself. The bench constituting the Honorable 9 judges pressed on how to balance individual rights versus group rights and whether any workable standard exists to review religious practices without excessive judicial interference. On days 10 and 11, the respondents argued that fundamental rights, especially equality, limit religious freedom. They said exclusion of women, even if it is framed as age-based, is discriminatory in effect, and that constitutional morality must override practices that cause exclusion or harm. The bench in this reference is also hearing the justiciability of excommunicatory practices, including those of the Parsi community. in another important case of Kumud Lal versus Suresh Chandra Roy, dead through Elas and others, the issue for consideration before the Honorable Supreme Court was that whether upon death of the doctor during pendency of proceedings at appellate stage, the legal heirs can be impleaded and held liable for the alleged act of medical negligence of the deceased doctor. If yes, to what extent? Herein, it was observed in view of the discussion and the statutory framework provided in the Consumer Protection Act 1986 as well as the Consumer Protection Act 2019 that upon the death of the alleged medically negligent doctor, his or her legal heirs can be impleaded and brought on record. Consequently, the extent of liability will be determined based on the pleadings and evidence presented. In a significant judgment in the case of Reliance Eminent Trading and Commercial Private Limited versus Delhi Development Authority, the Honorable Apex Court gave guidelines regarding summary judgment under the Rule 4 of the Order 13A of the CPC, which was brought by way of the Commercial Courts Act 2015. It was observed that the court's usage of power under Order 13A CPC is exceptional as it cuts short the process of trial and ought to be exercised where oral evidence and full trial is not required. Another update regarding a political storm. Recently, Raghav Chadha, a Rajya Sabha MP from the Aam Aadmi Party, announced that he and 6 other party MPs have merged with the Bharatiya Janata Party. In the Rajya Sabha, the Aam Aadmi Party has 10 MPs. He claimed that since 2/3 of AAP's Rajya Sabha members are part of this move, it would fall under the merger exception in the 10th schedule of the Constitution of India and not be treated as defection. Will the shift of the Aam Aadmi Party Rajya Sabha MPs to the Bharatiya Janata Party be treated as a valid merger under the anti-defection law, or will they face disqualification? Will the next thing to be observed. Lastly, the Union Cabinet recently approved the Supreme Court number of judges Amendment Bill 2026, which proposes increasing the number of Supreme Court judges by 4. If passed by Parliament, the court's sanctioned strength will rise from 33 to 37 judges, excluding the Chief Justice of India. That's all for today. Thank you for watching.